Hello everyone. I welcome you all in Pune Times Mirror. Today we have with us Adv S K Jain, who is a prominent, noted and renowned lawyer from Maharashtra. For last 5 decades, his services in legal fraternity is well known. Recently, despite India, which has got independence and we are celebrating our 75th year of independence, but on 1st of July will be a historical moment in India where the criminal laws that are there in India no longer will be the same as we have picked up from Britishers, the British Penal Code, which transformed into Indian Penal Code in 1860. But now India has got three important its own laws and which is Make in India development. For this, today we have with us Adv S K Jain, who is going to elaborate on the 1st of July, the historical revolutions which has took place in India in the legal fraternity, where India has got Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Sakshya Adhiniyam, which means the Indian Penal Code as well as the Code of Criminal Procedure and the Indian Evidence Law Act will not be the same. There is a significant change, and to know about this more update, we are going to know it from the legal fraternity, and we have with us Adv S K Jain, sir. Hello everyone, this is Chaitrali here, and today we welcome you all on the special show on this Pune Mirror. And today we have one of the noted prominent city-based lawyer. For more than 5 decades, he has his experience into legal fraternity. Let's hear from him the new changes that has brought in India and his contribution, and how do you look forward for it. Welcome you.
It's my pleasure.
So today we have with us Adv S K Jain sir, who is a city-based prominent lawyer, has more than 5 decades of experience into legal fraternity, as well as he is one of the criminal noted lawyer in a lot of cases which has been the new law that has come up. It's India on real tone. India has received its Republic of India that we have been saying it, because India has got his own law that is under this clause that we have from the 1st of July 2023. So how you welcome this?
Look, earlier the changes were there in the existing laws, like Criminal Procedure Code and others. But they were cosmetic changes. They were not basic changes which India as a country or Bharat as a country required. That was one part. Second part is concerned in 1972 when I joined the bar and started practice. It was an old procedure code of 1898 or somewhere there part. Then certain amendments were there. In 1973, Criminal Procedure Code newly came into force. There was no problem at all. Some sections were changed. Some amendments were there. And so till that time, means till that 1973 Criminal Procedure Code came into force, the cases were going as per the existing old laws and thereafter with the new laws. Same thing now will happen, that from 1st July 2024, whatever the incidences, offences occurred, they will be as per the new procedure, new laws, Bharatiya Nyaya Sanhita and Bharatiya Nyaya Procedural, and these parts are concerned. And earlier are concerned, they will be conducted as per the then existing law, that is Criminal Procedure Code 1973. So changes are there, important changes are there. We have to welcome, because it was a need of the time to curtail the delay, and to some extent will certainly succeed in it, and people will get the relief.
Thank you, sir. So moving on to the next question, we were the colonial of Britishers. So British Penal Code turned down to the Indian Penal Code of 1860. And so the amendments, like you said, that the amendments were taking place in 2013 also we could see the CRPC got changed after the Nirbhaya case. And after them, suddenly the transformation of the name that has come up. So they didn't, the parliament did not stick to the name of Indian Penal Code. They have mentioned it Bharatiya Nyaya Sanhita. So how is this transformation altogether?
Look, the question is like this, that earlier the Britishers had made the law with the presumptions that Indian natives are criminal, or to protect their rules, protect their government. They have always put all the drastic conditions with the presumptions that the person has committed an offense, and for punishment, instead of going to reformative theory, they wanted to punish to such extent that that will set an example that nobody will work against the wishes of the British government or against the interest of British government. So their object was to penalize as a setting example that they will not do it. Now with the UNO's reform at national, international level and with the parts, the constitution has a article 21 of constitutions which says that the liberty of the person has to be protected. In one of the case of the Joginder Singh's case, the Supreme Court in 1984 or somewhere, they have said that if one has to choose between death and defamations, then the person may choose death. देन बदनामी और मृत्यु, उसमें से आदमी क्या चॉइस करेगा? तो बोला मर जाना बेहतर है लेकिन बेइज्जती नहीं होनी चाहिए. सो नाउ दैट इज द बेसिक कॉन्सेप्ट विच द पर्सन हैज टेकन, विच द पार्लियामेंट हैज टेकन, एंड देयरफॉर टू हैव अ बैलेंस means society is to be protected by the law enforcing agencies, that offender should not go unpunished. But at the same time, the constitution's liberty says that a person should not be punished if he has not committed offense, and therefore he should be treated as innocent. And by keeping this principle in mind, as the Supreme Court from time to time has held that offender must be punished, innocent must be protected, by taking both these principles, they have made the changes. Second thing is concerned, considering the delay, the confidence of the public in judiciary was vanishing or reducing, and therefore they were finding alternative for getting their redressal of the grievances. So to some extent, it will have a check on it. The third part of it, the scenario has changed with the new technologies and new concept have came to force. Information Technology Act, we have got digital electronic media, we have got artificial intelligence. Now the world has become so small, the distances has gone, and therefore the nature of crime also has changed. To give an example, that now a woman receives a call and say that these friends are concerned on this Facebook and this internet and Instagram. Social media. And then the person say that I want to marry, for that purpose I want to give you gift. And then he say that I am sending you $2 lakh and some diamond and other gifts, costly gifts. She gets this one thrilled. For 2-3 times they talk on Instagrams and everything. And then he says that, oh, at custom, she receives the call that you have to pay custom duty, and therefore you deposit some lakhs rupees in account which she has been given. And the lady deposits. Then they say that there are transportations and other charges are concerned, courier charges you deposit. Likewise, these ladies are depositing 10, 12, 15 lakhs rupees, and then ultimately they found that fraud was pleaded. So that is the one way of it. Now there is a cryptocurrency. There are hacking of the data and other parts are concerned. Your accounts are concerned, not safe. So to consider all these things, the criminal angle has changed. The crime offenses modalities had changed. So to meet all these aspects, the new law was necessary, and therefore they have enforced. That is one part. And the second part, certainly, after achieving the liberty, freedom for 75 years, if still we are using the laws of Macaulay, then it is not good for a country which we are now independent, we are financially sound, we are everywhere we are leading to the international world, and therefore these changes we have to welcome.
So thank you, sir. So another question to you is the new changes, the new aspect that you mentioned about the women's laws, and do you like they have given more priority, even the child definition under this act has changed. The women's law are being considered on the priority terms. So new aspects related to women that they have incorporated.
Stalking, other women's laws, 354 is there. Then there are various amendments were there. There were lacunas from the point of view of collecting evidence and prove it. And that was the reason that normally the women's or females were not coming forward to give complaint because they were feeling that they may be harassed. They were feeling that they may suffer from their decency, their names, reputations. They were scared. So now the law says that there will be a witness protection scheme. And therefore that will help the persons to come forward and lodge complaint. Coming back to women is concerned, the insecurity is taking place at various places. Maybe in college, maybe on roads and maybe other places. And because there was a delay and there was a little protections to an attitude of some of the judges that they were saying that no, we'll give bail. And therefore people were not scared of law enforcing agencies. And therefore the incidences started growing. To curb this new amendment is concerned, we're going to take care. And the aggrieved party or victim will come forward, will give complaint. Now the module or the procedure of recording complaint had changed. That will go under electronic devices and other parts. The statement is concerned, then there was another part that the incidents occurred, she lodged the complaint. After a few days or after a few months, she's pressurized. Then she used to come and retract her statement. No, it won't be possible easily. Only under certain circumstances that if incidents has occurred with consent, when it was an understandable age, they wanted to marry and it really happens, then only the case may be disposed of without convictions. But otherwise, the evidence will be recorded in such a manner that it will not be possible to tamper by the accused and to retract by the complainant also. And therefore, by pressure or by inducement or with money allurement, the complainant used to go back to his statement. No, it will not be possible. And so real justice will be there in such kind of the offences which are against the society, even though it is against the individual, but these offences are against society. And to set an example, these changes will help.
So moving on to like what you have said about the society. So for the public, like very much in the law, if we look into the Code of Criminal Procedure, they have made it and changed it to Bharatiya Nagarik Suraksha Sanhita. So this is more people centric because we have seen that, now witness no need to come to the court. He can be
video
available
conferencing.
Video conference. But so how do you look this into a citizen viewpoint? No more pendency and how pendency and date on dates.
Look, the question is like this, that the changes has to be accepted. Because normally what was happening under the existing law, that for getting the presence of the witnesses, the matters used to be adjourned very often. For example, doctors, they will say that I am in a hospital, I can't come there in the court for 2 hours or 3 hours. But certainly from his office, he can give 10 minutes or 15 minutes to depose before the court. Or somebody is there who has got his own assignment, engagement. Or somebody is residing outside the campus, outside the jurisdictions, at a distance. And then only to accommodate him, the matter was required to be adjourned. So now once the evidence started recording, it can go on day to day. With the help of this video conferencing, there will no need of adjournment. And if the proceeding is started and completed from day to day, it will save the time and it will be expediting the disposal of the cases.
Yes, sir. So now it's a big challenge for police people as well as right to liberty is another aspect to it. Zero FIRs has come up, the new aspects related to it. Zero FIRs. Even terrorism is one aspect which now Bharatiya Nyaya Sanhita has covered up that aspect too into the law. And now there is a special law exiting the general law, that is this. So, and always a special law is governed more. But unto this, into this framework, how do you see this?
Look, what I can say that the procedure is concerned, it is going to help the police from the investigation point of view. Why? That earlier, the 15 days police custody was to given at a test. After 15 days are over, the police could not ask for the police custody. But what happens that in the beginning, police are not able to collect all the evidence required and with that help to interrogate the accused. So by giving the required reason, they can tell the court that at present 4 days police custody is sufficient by reserving their rights. Now it has been said that up to first 40 days, then 60 days, then up to 90 days. At any point of time, this 15 days can be utilized. So the word used is the total 15 days,
15 days.
in first 40 days, 60 days or 90 days. So that will help police to first collect the evidence and then to interrogate. Otherwise, what was happening that they can't afford the accused to escape, so they have to arrest. And after arresting, if all the evidence is not collected within 15 days, then it was difficult to prove the case. And so convictions ratio was less. So it will help them to have the conviction ratio more because there will be a scientific investigations with the help of forensics and other parts are concerned. And the statements are concerned, Panchnamas are concerned, there will be videographing. The statement also will be covered on this electronic media, electronic device. And therefore, as I have said earlier, that it will be difficult to become a hostile.
Property.
So far as the property part is concerned, no, a very good change has come. As far as we know, that there are number of crooks or the offences under the Prevention of Corruption Act. Offence is registered, the person get bail, and then the matter comes up for hearing after the years together. Now they have said that any proceeds of the crime can be attached and it can be disposed of. So suppose that an officer has amassed a wealth in crores, then that can be attached. That is a special provisions they have made in this new procedure code. And if suppose that he has taken by way of a bribe somebody and if that can be established, then that can be distributed. And we need not wait till the conclusion of the trial. So it will be difficult for a person or no, there will be a fear in the mind of public servants. If I collect the money or in the form of others, it can be. The second part is concerned that this property can be followed also. That X has committed an offence, he has received the property, he has handed over to Y, then he has handed over to Z, then the property can be followed from Y to Z also, and all this property can be recovered by the police officers by way of investigations, by way of attachment, and it need not be wait till. Now the second point was that there used to be a restrictions, that suppose there is a theft of gold ornaments, and they used to say that you have to keep in the same form till the trial is complete. And suppose trial is complete after 3 years, 4 years, and if these ornaments are used, then it will not remain in the same form. And if it is given on bond also, just to keep it in a box, it is of no use. So now the provision has been made that photographs will be taken and that will be remain and that will be treated as an original evidence or primary evidence. So the persons who is aggrieved, who is victim, will be entitled to get the property and use it.
So it's a very good move for the citizens. In the real sense, Nagarik, the term that has been used in the Code of Criminal Procedure, instead of Code of Criminal Procedure, they have used this Bharatiya Nagarik Suraksha Sanhita, which covers citizens' viewpoint and citizen-centric viewpoint, like victim and all these aspects. So do you think the major issue when anybody plans to come to the court is the pendency or the adjournments? Now the time-bound cases has come. Like we have come up ahead that after charge framing within 30 days or even after even the final arguments is taken, there is a time bound that is. How do you look into this? Are we well equipped now?
I will tell you. If you have read or come across the statement of Honorable Chief Justice of India in Calcutta, in the library's functions are concerned, he has stated that adjournment is appeared to be a normal things. And it is a routine things which is not good for judiciary. And that is likely so. But then the questions will be that if the cases are organized in a proper way, hearing and other parts are concerned, and if full time of 11 to 2 and 3 to 5 is used for the trial, then it will help us to curtail the delay. The second part is concerned, the mindset of the persons and advocates and prosecutors and the judges. If the teamwork is there, and if the board is organized in such a way, arranged in such a way, then certainly one will get the relief at a faster speed. The delay is concerned, certainly it is there. And that reason is that we have got a country of 140 crores. And the number of judges or number of courts are less. Moreover, our priority is towards the maintenance of the women's health, educations, even the farmers. So we cannot give the funds for the courts what is required. So the proportions of the judges and the public, what is in Singapore, what is in Australia, or what is in European countries, is far better than the India is concerned. And certainly it will take time because the governments has got their own priorities and how much to spend on judiciary is concerned. But one thing I will add, that government is getting lot of revenues because of judiciary. Government is getting lot of revenues even with the stamps in registrations. Government is getting lot of revenues from court fee stamps. Government is getting lot of revenues from fines and that parts are concerned. And if the view is taken that suppose that to convict and give a jail sentence is not required or by way of reformations, then it can be changed into putting the heavy fine, which will be exemplary, so that the persons will not be required to go in jail, but he will suffer to a great extent financially. You must be knowing that nowadays there is a thought that jails are overflowed. So ultimately, we have to find out a solutions that whether for each and every reasons the person should be sent to jail. And therefore, what they have used the word Nagarik Sanhita. So now the laws are taking into consideration the welfare of state and welfare of the citizens. Earlier, the colonial laws were only welfare of the state and not welfare of the citizens, or they were never taken into considerations the welfare of the individuals are concerned.
Okay. So by this, you mentioned that, earlier sometimes it's states makes law or it's the citizens who makes the law. But by this, it's the government has played a vital role to this aspect altogether. So to conclude, now we come up with the session that, I just wanted to ask you one particular question, the question that so you have geared up. As a lawyer, we have geared up. Judiciary has geared up. Are the police people or they have geared up? Because now we see if more aspect of digital aspect is considered.
I think that there also now police are equipped with the cyber laws. They are also given training of digital and other parts are concerned. So if there is well organized prosecution agency at police stations, then it will get a better result because then it will be a scientific investigations. And then there will be a less lacunas in the cases which will come in the court. And I think that for that purpose, more and more training is required to be given because there are always changes at national and international levels. The mode of crime is changing. No, Nigerian comes for so many other things are concerned. Drugs laws are there. So on the one hand, we say that innocence. On the other hand, it is difficult for police to go to the root of it, get the reports within the limited times of forensic and other parts are concerned. So certainly it may take a time little bit. We are in a development stage. But the laws and intention is such that public will have the faith and confidence in the judiciary and the criminal will have a fear of convictions that they will be having a mind that if we commit the crime with the help of delay in the trial, they will not be able to escape. And the basic principle of administrations of justice is that the timely convictions or timely result of the case is going to help the society at large to protect its liberty.
With this, we conclude and we hope that, more sessions with you can take place with us, sir.